Perfect, thank you. So I just wanted to ask really quickly, we were talking about eligible employees. The average of 30 hours per week, is that the same as the like kind of standard 1250 or is it 1280?
I actually looked that up this morning. It's actually a little bit more.
Oh, okay.
Yeah, depending on whether you do 50 weeks or 52 weeks. If you do 50 weeks, assuming a couple of weeks of vacation or whatever, it's 1,500 hours a year.
Interesting.
Yeah.
Could we hypothetically, like, I'm just looking at this like from an employer, like, and then we can kind of, legislate how we would like, but I think most employers are used to that 1280.
1250, yeah.
1250, thank you. And calculating eligibility, would it be difficult to change that or? In here?
I assume, but you have the power to do that. Because my understanding is that at the end of the day, the federal law is the floor.
Yeah.
So it's a little odd that this would be would require more hours.
Yeah.
Right.
Sorry. I put this on.
I would like to see that change. I don't feel super strongly. I personally would like to see that change if the rest of the committee is okay with it.
And your purpose would be that's kind of an eligibility requirement for other
And
stuff.
for the federal FMLA,
Yeah.
that's what the requirement is, 1250. So anytime I've ever said, an employer, because in my other job, I work kind of as a shared service. So an employer will reach out to me and say, I have this individual. And then I look them up. I say, okay, you worked for the organization for this many years. This is the many hours you work. And then I just make sure that they've in the previous year, met the 1250 requirement. So I'm, that this just would be a weird outlier.
Yeah, and then, and just so people are aware, for employer, I talked about the 10 or more individuals for the most of the leaves, and then family leave, it's 15 or more individuals. Under federal law, it's 50 employees, within a 74-mile radius. So that is more generous. It reaches further in this.
Yeah.
I'm happy to look at that and make the change consistently if that's what the committee is.
I would appreciate that. Thank you, Sophie.
All right, so turning to section 3, which is on page 7. So there isn't really much change here. It's again, they've moved some of these definitions have gone from section 472 into the definitions section. So it's sort of a realignment. And then it just adds in that during any 12-month period, an employee shall be entitled to take unpaid leave for a period not to exceed 12 weeks. And then it lists out the types of leave. So parental leave, family leave, and then these new leaves, safe leave and qualifying exigency. And then subsection 2 on page 8 just clarifies that for bereavement leave, an employee may use up to 2 out of the 12 weeks total for bereavement leave. So it's not 12 weeks for bereavement leave, it's up to 2 weeks. Subsection B in the middle of page 8 just adds, and again, it's up to the employee's option to use, so this is unpaid leave generally, but if an employee has paid leave available to them, the employee can choose to use paid leave. And this adds in short-term disability to the statute as the type of leave that the employee can choose to use. Right. And then the notice section, this is at the end, bottom of page 8. Again, those are largely technical corrections at the bottom of page 8, but page 9, subsection 3 at the top, just explains that if you have an unanticipated serious health condition, such as, premature birth, death in the family, whatever it may be, that you need to give your employer notice of the need for leave. It's practical. The next section, section 4 in the middle of page 9, starts talking about the documentation that's required for the different types of leave. I don't know if I need to go through all those. I'm happy to do so if folks have questions. But if you're taking safe leave, what documents can an employer ask you to provide? On page 10, at the top, it has the documentation for bereavement leave, subsection D in the middle, the documentation for qualifying exigency leave. Page 11 just has one technical change on it. And again, this doesn't change the standard provisions that already exist in the Parental Family Medical Leave Act in terms of, an employer is free to adopt more generous leave policies if they choose, collective bargaining agreements, etc. Subsection H in the middle of page 12, starting at line 8, just adds, if an employee goes out on one of these leaves and then doesn't come back, you can be required to return the value of any compensation that you received unless you were out because of the serious health condition of the employee. And this just adds in safe leave. So if somebody takes this leave for a safe leave situation, they're not required to return any compensation to the employer. Section 4 at the bottom of page 12, getting into short-term family leave. No changes there. And again, the changes on page 13 to that particular section is really just making it clear that all these apply to family members, that new expanded definition. And you can see that previously it was limited to child, stepchild, foster child, or ward. There's that more expanded definition of who a family member is. And so any of those family members, accompanying your, an in-law to, a medical appointment, whatever, would now be covered under the short-term family leave section. Section 5 at the bottom of page 13, this is talking about leave for crime victims. So this is a little different to safe leave. This is just explicitly allowing employees to take leave to attend a relief from abuse hearing under the law, and it takes out the order against stalking or sexual assault because that's now covered under the safe leave definition at the beginning of the bill. So any additional questions?
I just want to say that I really want this to be something that the committee really collaborates on, and please don't hesitate to speak up if you have any thoughts or suggestions on, any of the language, or if you'd like to see tweaks, please don't hesitate to save them, or I really want this to be something that we all are invested in and talk about. So please don't hesitate to speak up if there's anything in the bill that you feel like could be tweaked. I'm not, wedded to every ounce of language. Please feel empowered to add or change as you see fit.
I've got a question. Here on page 5, when it's talking about safe leave, it's domestic violence, sexual assault, or stalking are 3 separate categories. Is that right?
Yes, and they're separately defined. So if you look further down on page 7,
Yeah, I got you.
14, 15, they're defined. Yeah.
So on 14, sexual assault, I'm not familiar with the statute, and I don't know whether you are
Take a
off the
look
top
at
of your head or not. But,
it.
does it require a police report or a conviction?
So I would just say for safe leave, when it talked about documentation for safe leave, on page 9, it says an employee may provide documentation from any of the following sources. So a court or law enforcement or other government agency, a domestic violence, sexual assault or stalking assistance program, a legal, clerical, medical, or other professional from whom the employee or the employee's family member received counseling or other assistance. It also includes a self-attestation by the employee. So it's any one of the following.
Okay.
So yeah, so an employee can submit a self-attestation to the employer if
Thank
they choose to do that.
Does it go without saying that the confidential information of the documentation doesn't go anywhere else?
Yeah, so there's actually language on that in here as well. So if you look on page 10, subsection E, line 12, an employer, well, this is medical, but an employer shall not disclose any private medical information or information relating to a safe leave that the employer receives. So again, the employer is entitled to receive documentation, and it can be certification, it can be a medical provider if there's a medical issue, but usually HR for employers are aware that they have a lot of confidential information, and they're usually for medical records, they're required to keep those separately locked away. So, I mean, they're usually used to working with that. So yeah, it would be, so the employee has to tell the employer, but the employer is required to keep the information confidential.
And the only way that they could get that information is a court order.
Well, it would be if the employee chooses to share it, the employee could be comfortable with allowing information to be shared. I guess it would depend. I mean, you could have a court order.
That's what it says on line
Yeah.
16.
Medical provider do this on request, or are they constrained by HIPAA?
So, they can do it they can be requested to do it. So if someone's seeking to take a leave for a serious medical condition, whether it's theirs or a family member's, they can be, in order to get the leave, they need to be required to provide medical certification. And so usually the individual would then be asking their medical provider to complete a form to
Go ahead.
say what's needed.
Can the employer demand detailed medical
No, they can require a certification,
certification?
but not the detailed medical records.
And as an employer, you can ask for a more, like I received this documentation that was very clearly filled out by somebody in a office, like administrative staff, and didn't give any information, just this person's going to be out from this date to this date. And nothing else was filled out. You can ask, no, it does need to have more detail, and I need to understand the reason why this person will be out. But you can't say, what vertebrae are you cutting into?
But not the actual medical records themselves. It's a certification that's provided by a medical.
I've got another question. It's sort of related. Is a personal attestation also covered under confidentiality?
Yeah, this was under the safe leave.
Yeah.
That was also covered on that, the one we just looked at. An employee shall not disclose any private or information relating to a safe leave.
I keep losing my.
Page 10.
Thank you.
Page 10, line 13.
Well, okay. I'm thinking of page 9, line 19. Okay, page 10, line 19.
So an employee can submit a self-attestation to the employer, but the employer has to keep that confidential
Okay, just want to make sure that's left tight.
to the extent permitted by law.
There are other questions? I know it's new day.
Do we need to get done?
Oh, no, we were just laughing because I'm in charge now. Yes. Go ahead.
All right. Self-attestation, it says no further corroboration shall be required unless otherwise mandated by law. So what would the other mandates?
I'm not aware of any off the top of my head. I think that's just a catch-all, just in case there's something where I know you need more than that. But for purposes of this leave, then I don't know. I mean, that may be if it's, I don't know if it'd be safe leave in connection with a military thing. I don't know if there would be some federal law that would say you need more, but For purposes of this, if an employee comes forward and submits a self-attestation about why they need to take unpaid leave to deal with a domestic violence situation or whatever, that's making it pretty clear they're not going to need anything else beyond that.
So the employer has to accept a self-attestation.
Right.
Got it. Okay. Like an employee
It says an employee,
could
they could
offer all of these other more official documents, or they could just simply offer a self-attestation.
up to the employee.
That's all up to the employee what to offer.
Right.
Okay.
Any other questions at this time? Right.
And I will look into the 1250 federal number of hours and then the 30 hours in this, because there must be a reason why.
Yeah, that is.
That was chosen,
That's a
but
good flag to look at, and maybe this has an idea, I don't know, yeah, no, that's great, thank you. All right, this is one. Oh, Megan is here. Yes. Don't tempt me with a break. Right, okay, thank you so much, Sophie, I really appreciate it.
Thank you.
Okay, we have our next witness here is Megan Sullivan, Vice President of Government Affairs for the Vermont Chamber of Commerce. Megan, this is not her first time in our committee session, so I don't think we need to do introductions, and we had you in previously, and now we have a new bill in front of us, so we would love to get your feedback and your thoughts and take it away.
Thank you, committee, for having me back. For the record, Megan Sullivan, Vice President of Government Affairs for the Vermont Chamber of Commerce. I apologize that I just am running into the building and into the committee room, so I don't have the bill language up on my computer yet, which is taking a hot minute. But I had previously seen the draft language of the new bill. And when I testified on this bill, I guess months ago now, which,
Right?
it sort of raised a broad concern of, it's helpful for businesses to have flexibility around how they structure benefits, so that because different types of employees want different things, and that flexibility allows smaller, medium-sized businesses that are really trying to fight for being competitive, an opportunity to offer, innovative, flexible solutions. The more sort of mandated benefits that happen, the harder it is to offer that flexibility. But understanding this is important to the committee, we did a deep dive into the language, and I mentioned 4 areas that were that we saw some challenges. This bill has addressed all 4 of those issues, and I thank the committee for their work on that and their willingness to listen to the business community's concerns there. I'm happy to go through those again if that would be helpful. Again, still not loading, but I can do best for memory if that would be helpful. Otherwise, just to say, I think the way this is written now has addressed those concerns, and we appreciate that.
Yeah, I think that was kind of my goal was after, really hearing from folks and seeing that we could get to a compromising situation. And so I appreciate that feedback. Would it be helpful for folks if Megan ran through her concerns again, or did you have?
Yeah,
Oh, okay. Yeah.
if that would be all right.
Absolutely. I'm still not loading, so I'm going to do my best for memory here, but I think the first area of concern we have just was that the safe leave didn't match up with other leave. So instead of being I think it was 15 employees and 30 hours, it was 20 hours and 2 employees, and it just would create a lot of confusion for businesses, that are on that sort of cusp of when do I fall under these laws and when don't I fall under these laws, and which employees are eligible and which employees aren't eligible. The more continuity we can offer in that creates some predictability and helps businesses get this right when they have to offer a benefit. If there's predictability and, okay, I've grown, I've reached that threshold. I know that I need to have these things in place, and these are the employees that they are in place for, sort of across the board, is helpful. So we appreciate that change has been made to put safe leave in line with the other leave in the bill. Or in statute now. The other piece was around the bereavement leave, the way the other bill was written, it had 2 weeks of bereavement, which was a pretty big outlier from what other states are doing. I think there's 7 other states that have bereavement leave in statute, and 2 weeks was more than what any other state was doing. So this scales that back to 1 week of leave, which is more in line with what we've seen other states that have offered this have done. The third piece was, we think it's important that the definition of family more accurately reflects what families do look like, that it's inclusive of our LGBTQ plus communities, that it's inclusive of grandparents and other family structures and dynamics that are part of our society. And so we are supportive of those definition changes. There was one additional definition that was really, I think, problematic in terms of how is an HR director or a business owner supposed to understand what this means. It's much more of like, if you feel like they're family, then they would qualify. And that's, I think, just could lead to some really big challenges. We want to be inclusive, but we need to have some clear guidelines around that for those HR directors, for those employers to understand when someone comes in and asks, that they can see, what the statutory guidelines are. So we appreciate that adjustment. And the last piece was around reporting. The reporting requirement in the original bill was to gather data around if sort of LGBTQ plus community members, employees were accessing this type of leave. And that was a real red flag for us, because we didn't want to put employers in the situation where someone was saying, I'm going to be taking unpaid leave for this, and the employer has to say, okay, I need to know your sexual orientation, I need to know your family dynamics, because I'm going to have to report it to the state. Employers don't want to do that. I don't think the state wants employers to do that. This is going to, if this becomes law, then they have to do it. And so, I think the idea of reporting maybe is something you do beforehand to find out, is this something we need? Is this solving a problem? If you're putting it in statute, you've statutorily said this is now the law of the land. And so we appreciate that part has been removed. So those were the 4 things that I had brought up in testimony last time, and those 4 pieces have been addressed in this new bill.
No, thank you so much, Megan. Does anyone have any questions for Megan? Oh, yes, Sophie.
Sophie Fidani again, from the Office of Legislative Counsel. I just wanted to flag it is bereavement leave up to 2 weeks. It's not 1 week.
Oh.
Well, I guess our case still stands on.
Okay, so it's
1 week elsewhere.
okay.
It
Make it more
provides that you
common.
can use up to 2 weeks of the 12 weeks for bereavement leave.
Right.
And what was your feedback was?
I thought the draft I had saw brought it down to 1 week.
Okay,
There is a 1 in that new language, but it's
it's somewhere else.
subdivision 1.
Oh, okay, so, can we, flag that for discussion? That might have been my error in the adjustments.
If it's helpful, I have a summary of the bereavement leave from other states. I could just quickly share with the committee.
Yeah, I had asked to kind of, yeah, okay, that would be helpful, thank you.
Do you want me to
Oh,
move or?
does anyone else have any more questions for Megan? Yes, Gail.
For you, actually.
Me?
So you would rather it be the 1 week?
I think I'd like to talk about that as a committee to see, and hear a little bit more testimony. I'm open personally. I'm open to, that's not a deal breaker either way for me. in the bill. I think my intent, the most important part for my intent is to make this as inclusive for families and people's definition of LGBTQ plus and others, and then also to add, it's really important for bereavement and safe leave are two provisions that I think would really increase the impact on unpaid leave for our state, and that's kind of where I'm at. But yes, Elizabeth.
Just to be absolutely clear, this mirrors FMLA, which goes beyond the bereavement leave that you already have at your place of employment.
Okay,
So if you exhaust your bereavement leave at your place of employment, this adds another week of unpaid bereavement leave.
okay.
And different employers also have different, some people offer very robust packages, different, it depends. So this is just if those are things aren't offered.
So for example, if you, when my father died, I only had 4 days of bereavement leave at my job. And I had to plan and execute his funeral. And
So this would extend those 4 days.
this would extend those 4 days.
To
That's
another
right.
7 days. That's very short.
It
It
is.
is, yeah. I mean, many folks know from last biennium, I had the loss of my mother, and it was very challenging, and being here and still doing a lot of that process. And so I just think that, many folks in the sandwich generation, like myself, and then others who are, balancing a lot, this is something that is important for today's world, that we honor those folks who are grieving. And again, it is unpaid, right? So it's not, yes, Mary.
And it also, if you need to travel any distance,
Totally.
it's travel time, it's making arrangements, it's going through the whole process that you certainly need. I had 3 days leave when my husband passed, and I had was allowed to take vacation time, which down the road, you really do need a vacation, a break, but I think this is a good bill. I wish it were paid leave. We, we're like one of 2 countries that don't have that. So I really support this bill. Thank you.
It's also a cultural thing. There's certain cultures that, like in the Italians, we do 3 days of a wake.
Oh, yeah.
And so that's preparing, and then the wake, and then real bereavement, that's not happening during that time. As far as, processing the loss.
No, I think it's a very important addition for the impact for people to have these provisions, and as well as domestic violence, which we obviously know can be yes.
And I had someone mention to me, well, if my employee is out a week or 2, I lose 30% of my business. I suggested that maybe he needs to do cross training. He himself needs to do training. He should know every aspect of his business. I mean, you can't control
Life.
life, exactly. You can't control what happens.
Yeah, but if you're running a clinic and your x-ray tech is out, you're not going to learn that quick. So there's some situations where that's a really difficult thing to do.
But there shouldn't be one person holding the key. There should always be someone else that can fill in, especially the example you're giving in a medical situation.
Sure, maybe
I-
that's not the best example, but.
I think, well, but I think an
I would want to take
ideal,
my accountant's place.
I think in an ideal situation, that would be great. We would have folks who could do everything, but we have 2 job openings for every job seeker. There is a workforce challenge in this state. You may be desperately trying to hire a second X-ray tech. And you can't find somebody. I mean, we are in a real challenging employment situation in the state. And I want to be clear, we're not saying no to this. But we are saying, here's what other states are doing. Can we take a step that aligns with where other states are, that does offer this benefit and doesn't, make us an outlier. I think I know individuals are struggling, businesses in the state are struggling as well, and we need to find a balanced approach to making progress.
I believe that is the intent, and what I kind of did was take the feedback and with collaboration from folks who are employees, employers, and the business community, and really strike that balance and not have a first in the nation, but just something that keeps up with the needs of Vermonters to have equity in who gets to take the leave. And those definitions are really defined and expanded for families. So I think that was really the intent. So I really appreciate you coming in and on short notice. And if there's anything else that you would like to add, feel free to shoot us an email.
Great, thank you so much.
Thank you.
You.
Okay, it looks like our next witness is not here. Is that right? She's at 11 and we dealt with that last time, so we don't want to push.
Yeah.
Sophie, did you have something you wanted to add? Thank you so much, Megan.
Here.
Again, Sophie Zadatny for the Office of Legislative Counsel. I just wanted to touch on other states and their bereavement laws. So there are 5 states that I looked at. So California, they're all got different permutations and whatever. So I'll just give it at a high level. California, a covered employee has five or more employees. For the employer, employees have to have worked at least 30 days. There's up to 5 days per covered family member, no annual limit. So if you were tragically to lose more than one family member, you would get 5 days per family member. Have to be taken within 3 months of death. It does not count against your 12 weeks of potential unpaid leave. So ours would be 2 weeks of that 12 weeks. Illinois has, for covered employer, is the FMLA. So it's the 50 plus employees within a 75-mile radius. And then the 1250 hours of service, and you have to have worked for the 1 year. They provide a maximum of 2 weeks or 10 work days to attend a funeral, make arrangements, or grieve taken within 60 days of death, up to 3 qualifying events a year. So it could be a total of 6 weeks. Again, would be a terrible tragedy to lose 3 family members in a year. And again, that would count towards the 12 weeks of unpaid leave. Maryland, covered employer is 15 or more employees. And their act allows eligible employees to use accrued leave, any of the accrued leave that they have for bereavement. But they're quite restrictive on who you can use it for. So again, it's that very immediate family members. Oregon, 25 or more employees is the covered employer. You have to have worked 180 days with an average of 25 hours a week. They also provide up to 2 weeks or 10 work days to attend a funeral, make arrangements, and for grieving within 60 days of death. It allows the use of the leave under Oregon sick leave law. So you can, if they're paid sick leave law, so you could use it if you had it available to use paid leave. And then Washington state covers all employers. There's no requirement that an employee's worked a certain amount of time, and that's up to 3 days of paid leave. So anyway, there's a significant variety, but there are a number of other states that would allow at least 2 weeks of bereavement leave. So I just wanted to make sure everyone was aware of that.
Yeah, and can you remind the committee how many other states have bereavement leave? Was that the ones?
It's the 5.
That was the 5. Okay, I didn't know if that was just a sampling of different. Okay, so there's 5.
That was 5 back in 2003. It looked like there was legislation in a couple of other states, Massachusetts and New Jersey. I'm not
Right.
sure if those have
Okay.
other states are starting to look at this as well.
Yeah, I can check. And ours is not in the current language in the bill, how does ours compare? Was ours comparable to another state or?
So ours would be up to 2 weeks of leave and it counts against your 12 weeks of leave. And you have to use it within
Okay.
1 year of the person's death. And the 1 year
Right.
is because of the settling in a state, et cetera, which obviously isn't going to necessarily happen within.
I was jotting things down and missed the number of employees for Illinois.
Illinois, yes, it's under the FMLA, so it's the 50 employees.
Okay, and
To be a covered employer, to be an
Yeah.
employer that has to provide it.
in Washington, you said up to 3 days and that it's paid.
Up to 3 days of paid leave.
Yeah, is there anything that is there any unpaid leave beyond those 3 days?
Not specifically in that particular law. It's under the Oregon Family Leave Act. I can give you the citation if you want on that, but it's up to 3 days of paid leave. Eligible employees may use family leave up to 7 days for the death of a child. Paid leave can also, I think you can also use if you've got other accrued leave. Again, it's a narrower definition. It's a death of a family member or household member, so it's not as expansive like if it's an in-law or someone that doesn't live with you.
Yeah, no, it's helpful. So what I'd love if we could just put a pin in that piece that Rep. Bartley had a comment on, and that will be a policy decision for the committee. And I'd like everyone to weigh in on it. I have no preference personally. Yes, Leonore or. Rep.
Sorry, I didn't mean to draw, I just want to let you know.
No, you're
that
good.
Oh, I was just wondering, Sophie, does this apply at all to some of the larger farms in our area or is it only
It covers
all
all.
businesses, all
Yeah,
employers?
yeah, all employers.
Thanks.
The other piece, just to follow up on the conversation that you were having before, if you look at page 11 of the bill or the strike amendment, under F2, line 12, if you have an employee that performs unique services and you need to hire a permanent replacement, that would be a reason, because really this act is about, one, preserving job protection and maintaining healthcare benefits. So there are a couple of situations where you don't have the job protection, and one would be if you would have been laid off anyway, you just happen to be out on leave. And the second one would be if you perform unique services and the employer has to hire somebody to replace you while you're out. So just I just wanted to close the loop on that, as there was a
Yeah,
conversation.
no,
about
this
it.
is really important.
And that's in the current statute. That's not a change.
Yeah, I think that's definitely, yeah, so I'd love to put a pin in that piece so that we can kind of come back and make that decision. Does anyone else have any other questions for our legislative counsel, who I know will be back and available? It's like you and Cameron just trade in seats, but we can, if not, we can take a break until our next witness appears.